Good morning, everyone, and welcome to our webinar, Medicaid iBudget Waiver Eligibility and Crisis Applications. My name is Robin Coker. I'm the Director of Communications at Disability Rights Florida. I'm a white woman with blonde hair, wearing glasses, and a burgundy-colored shirt. On the screen, we have a PowerPoint slide with a purple background and orange and white graphics and lettering. Our speaker for today's webinar is Caitlin Clibben, an attorney and Disability Rights Florida's Director of Community and Health Services. First, we will review the accessibility features of this webinar. Our webinar includes closed captions and American Sign Language. Closed captions are available at the bottom of your screen by using the button that says CC. In the chat, there is a link to view an external caption. You can click that link to have your captions appear in a separate window on your computer. We also have two American Sign Language interpreters today. They are spotlighted on your screen and should be visible at all times. If you cannot find them, make sure your participant setting shows all video participants. If you have questions during the webinar, please submit them in the Q&A. The Q&A button is at the bottom of your screen. You can also send your questions to the email address webinar@disabilityrightsflorida.org. Lastly, this webinar will be recorded and posted on our website and YouTube channel. Now that we have our housekeeping complete, I will pass things along to our speaker, Caitlin, who will begin by providing a brief overview of Disability Rights Florida and the agenda for today's webinar.
Thank you, Robin. I'm Caitlin Clibben, and I am the director of our Community and Healthcare Services team, our team that does the bulk of our work relating to the iBudget waiver. At Disability Rights Florida, we have funding, responsibility, and authority under 9 federal programs to protect the rights of Floridans with disabilities. We've been a nonprofit in Florida since 1987 with offices in Tallahassee, Tampa, Gainesville, and Fort Lauderdale. Our mission is to advocate, educate, investigate, and litigate to protect and advance the rights, dignity, equal opportunity, self-determination, and choices for all people with disabilities. So today our presentation is about the eligibility criteria for the iBudget waiver. There's a lot of information packed in, so I apologize if I go quickly, but I will try to keep it reasonable. We're going to learn about the eligibility criteria, how to submit your application and your documentation. So we're going to learn about the deadlines that the agency has to respond to your application. We're going to learn about crisis, those eligibility criteria, how to submit that application, and the deadlines for crisis applications. And I just wanted to say quickly that we can't advise you on your specific case, and I don't want anyone putting personal information, in the public. We have a intake team, so if you have questions about your specific case, please contact our intake department and they will speak with you, and if necessary, forward your case onto my team for assistance. And I'll also say that while I do have information in this presentation about all of the diagnoses that can make you eligible for the iBudget waiver, I'm going to focus mostly on autism and intellectual disability, as those are the 2 categories where people most often have difficulty gaining eligibility. I put all the information in for all categories so that people who come back and view this later will have those slides, but I'm not going to go through everything in depth on the other 5 diagnoses. So the most basic criteria, just to even be considered, you have to be Medicaid eligible. You have to meet the level of care for an intermediate care facility. You have to be, or higher. You have to be diagnosed with 1 or more of those 7 qualifying disabilities, and you have to meet the eligibility requirements that are in Chapter 393. And we'll talk a little bit more about that Chapter 393, but I'm going to go through each of these 4 basic criteria and talk about how they work together. So the first criteria is Medicaid eligibility. This is, kind of the most basic step to being eligible for the iBudget waiver. iBudget waiver is a type of Medicaid. You have to be Medicaid eligible. There are several large buckets of people who tend to be Medicaid eligible in Florida: children, pregnant women, children in foster care, Social Security income recipients, seniors, people with disabilities, individuals who are blind or and low-income people who need hospice or institutional care. Those are your basic buckets of people who might be Medicaid eligible. You still have to meet income and asset limits for any of those categories. Next, as far as the income and asset limits for the iBudget waiver, unlike general Medicaid, for the iBudget waiver, the applicant is considered a household of one. So only their income counts, even if they live with family, even if they're supported by parents or someone else, their own income and assets is all that is considered. And one little wrinkle is that if you say you applied for the iBudget waiver and you've been approved, but you have too many assets, so you're not Medicaid eligible, you will have 1 year to spend down your assets to become Medicaid eligible before you lose that waiver slot. So you do have some time to address basic Medicaid eligibility. So the second one of those basic criteria is meeting the level of care for an intermediate care facility in ICF. So that determination on your level of care is made by the Agency for Persons with Disabilities. The agency, to look at level of care, they're looking at major life activities and what they call handicapping conditions to determine your level of care. So when we talk about what they're actually looking at, when they look at whether a condition is handicapping, the categories they're looking at are ambulatory, your ability to walk, sensory, chronic health, and behavior. And then as far as major life activities that might be impacted by these quote unquote handicapping conditions, what they're looking for is under major life activities, they're looking at the categories of self-care, understanding and use of language, learning, mobility, self-direction, and capacity for independent living. Okay, so that last slide was about your level of care, and now we're going into having a qualifying diagnosis. So Florida has decided that for the iBudget waiver, they don't consider every single thing that might be called a developmental disability. They only consider these categories. So the diagnoses in Florida that can qualify you for this waiver are autism, cerebral palsy, intellectual disability, Prader-Willi syndrome, spina bifida, Down syndrome, Phelan-McDermid syndrome. There's an additional category for kids between 3 and 5 who are at high risk for a later diagnosis of one of those diagnoses I just read out. And we'll talk more about how they determine if you're at risk or not. So the fourth basic criteria on that earlier slide was meeting the eligibility requirements in Chapter 393. So Chapter 393 lists those diagnoses I just talked about: autism, intellectual disability, cerebral palsy, etc. And that statute, though, also gives the agency for persons with disabilities the authority to create rules to implement that statute. So there's additional definition within those rules, but that's still a part of meeting the definition under Chapter 393 because the rules flow from 393. So APD has created rules in our Florida Administrative Code that provide additional detail and definition about the diagnoses and the eligibility criteria. And the agency rules that we are mostly talking about today are 65G-4.014. That's where you're seeing the additional definition, and some of them give you some factors that you may need to meet. The second rule is 65G-4.017. And that one gives you information about who needs to make the diagnosis. Sometimes it's a psychiatrist, sometimes it's a medical doctor. We'll talk about that with each different diagnoses as we go through this presentation. So first, I'm going to talk about the autism category. And remember earlier, I said autism and intellectual disability are the two diagnoses that typically folks have the most difficulty with as far as becoming eligible for the waiver. So I'm going to focus most of my time on those. First, autism. The Chapter 393 definition is that it is a pervasive, neurologically based developmental disability of extended duration, which causes severe learning, communication, and behavior disorders with the age of onset during infancy or childhood. Individuals with autism, this is also from Chapter 393, they exhibit, as far as being eligible for the iBudget waiver, they must exhibit impairment in reciprocal social interaction, impairment in verbal and nonverbal communication and imaginative ability, and a markedly restricted repertoire of activities or interests. So, now looking to the rule that the agency promulgated from that statute, the rule has added some additional definition for some of those words that were in Chapter 393. So they want it to be pervasive, and the rule says pervasive means always, present, and without interruption. The statute says neurologically based, and the rule explains that they mean that that's not the result of a physical impairment, it's the result of neurologically based issue. It has to be of extended duration. They say that means it must reasonably be expected to continue indefinitely into the future. It must cause severe learning disorders in both severe communication disorders and severe behavior disorders. And you prove that you have met that last prong, the severe communication disorder and severe behavior disorder, by meeting at least 6 of the 12 factors that the rule lays out. And we're going to go through those. The factors are broken into 2 parts, and you have to have at least 1 factor from part 2 and 1 factor from part 1. The rest can come from either of the 2 parts, but you got to have at least 1 in that section, in that part 2. So, and then here is that second rule I mentioned about who has to make the diagnosis. So for autism, the diagnosis has to be made by a Florida licensed psychiatrist, a Florida licensed psychologist, a board certified pediatric neurologist, a board certified developmental pediatrician, or it can be collateral information from another state if the evaluator from that state is licensed and has basically the same credentials as they would require in Florida for licensure. So for folks who've moved here from out of state and their evaluation is from New York or Wisconsin or wherever, as long as their licensure scheme for psychiatrists and psychologists is similar, it should be fine. Okay. And so now we're going to go through those factors. These are the 12 factors I was discussing where you have to have at least 1 from part 2. So I'm going to break them down between the parts. So first we're talking about part 1. Part 1 looks at the communication side of thing. Part 2 looks at the behavior side of thing. So for the communication factors, you have to, like I said, at least 6 of these 12. So they are a delay in or total lack of the development of spoken language, a stereotyped and repetitive use of language or idiosyncratic language. For those applicants who do have speech, they might have a marked impairment in the use of nonverbal behaviors like eye-to-eye gaze, facial expression, body postures, gestures that you typically use in social interactions. It may be a failure to develop peer relationships on an appropriate developmental level. So we're continuing with part 1. So also a lack of spontaneous seeking to share enjoyment, interests, or achievements with other people. They give an example that could be, a way you might measure that is they don't show or bring or point out objects. They don't tell other people about their achievements, that sort of thing. Another factor is the lack of social or emotional reciprocity, or the marked impairment in the ability to initiate or sustain a conversation, or the impaired imaginative ability evidenced by a lack of varied, spontaneous make-believe or social make-believe play at the appropriate developmental level. So all those factors I just read are all from part one. And then the next part two, just has four. So you got to get at least one of these four. Encompassing preoccupation with one or more stereotyped and restricted patterns of interest that's abnormal, either in intensity or focus. Apparently inflexible adherence to specific non-functional routines or rituals. Stereotyped and repetitive motor mannerisms like hand flapping, twisting, whole body movements, and then persistent preoccupation with parts of objects. So that's all that's in part two, is just those four, and you got to have at least one of those four, along with, 5 more to meet your 6 of 12 criteria to qualify under the autism diagnosis. And these are not easy to meet. They have to fit in with all of the other parts. So if they want it to be severe, pervasive, lasting, or expected to continue indefinitely, right? So if maybe the person had hand flapping behaviors when they were younger and they no longer do that, it's probably not going to rise to the level for the agency, because that did not last an extended duration. That was something that happened at one point and no longer continues. So, meeting these 6 of 12 criteria is not always easy, and you're definitely going to want to have documentation about each of the 6 factors you're trying to prove. And I always recommend that if folks think that they can prove 7 or 8 or 9, however many, go try to prove as many as you can, because they may disagree with you on 1 or 2. So if you prove a couple extra, then you should be good. So don't say, okay, I've got my 6, I'm done, I don't need to do any more. You're going to want to try and prove as many of these 12 as you possibly can through your documentation when you submit your application. And we're going to talk a little bit more about documentation and submitting the application once I get through the criteria for the different categories. So next is intellectual disability. This is the other category that we most often see people having difficulty gaining eligibility under. So Chapter 393 of our statutes defines intellectual disability as significantly sub-average general intellectual functioning existing concurrently with deficits in adaptive behavior, which manifests before the age of 18 and can reasonably be expected to continue indefinitely. Oh, what does that even mean? So, adaptive behavior, they've defined as the effectiveness or degree with which an individual meets the standards of personal independence and social responsibility expected of his or her age, cultural group, and community. Significantly sub-average general intellectual functioning means performance that is 2 or more standard deviations from the mean score on a standard intelligence test specified in the rules of the agency. So that is just a lot of words, but what that really means is they're looking for an IQ score done with a certain type of test, and the rules do specify which IQ tests they will accept. I didn't list that here, but it's certainly something you can go back to in the code, and something you can call DRF on our intake line if you're having more questions about it. And when they say 2 or more standard deviations from the mean score, yada, yada, all that means is that your IQ is 70 or below. So they're looking for people with IQs who are 70 or below, who also have those deficits in their adaptive behavior. and it has to manifest before 18. So, okay, going into the rule to get our more detail about how they've defined intellectual disability, when they talk about adaptive functioning, the domains that they're looking at as far as what areas you would be functioning in are communication skills, self-care, home living, social and interpersonal skills, use of community resources and self-direction, functional academic skills, work, leisure, health, and safety awareness and skills. So they're looking for deficits in those domains. And then they're looking for some proof that these deficits are substantially handicapping, which by that they mean interfering with your ability to do your activities of daily living, and then it must be reasonably expected to continue indefinitely. There are some people who, because of medications or other external factors, might score low on an IQ test at one time and then do better later. So they're looking folks who it's not some external factor causing a artificially low score, and they want this to continue indefinitely. Okay, so when they are looking at who diagnoses intellectual disability, they are looking for someone who they're looking for that IQ test. Those when they're measuring your IQ, they're looking for something that's validated by the professional judgment of a psychologist, experience working with people who, and please excuse the language here, this is from the rule, experience working with people who have retardation, intellectual disability, and who have specific training and validation in the assessment instrument. So the psychologist or psychiatrist, whoever's using the IQ test, needs to be trained in how to use that particular test. And it has to be a Florida licensed psychologist, Florida licensed school psychologist, or a certified school psychologist. So that's the basic definitions that come out of Chapter 393 and the Florida Administrative Code for autism and intellectual disability. I'm going to very quickly go through the other 5 diagnoses just so you can see it here on the screen. But I'm not going to spend as much time on these because I don't want us to run out of time. So the next diagnosis I'm going to talk about is cerebral palsy. Again, they have their own definition, or the medical definition, and then what they've adopted. Again, like what we've discussed before, it has to manifest prior to age 18. And the one thing I want to point out here is this third bullet point on this slide. They're specifically including any sort of cerebral palsy type symptoms that are caused by something else, like a stroke or a progressive disease like multiple sclerosis. So you might be able to say you have some of the features of cerebral palsy, but if it's caused by something else, that will not suffice here. And again, it still has to impact you such that they consider it substantially handicapping and that it is reasonably expected to continue indefinitely. Here is the list of folks who need to make the diagnosis of cerebral palsy. Generally, you're looking at a medical doctor here. The next category is Prader-Willi syndrome. This is a very specific syndrome with a specific way of being diagnosed, and it's pretty easy to say yes or no, do you have this? So that's why we don't see as many challenges under this category. And the administrative rule definition is here on the screen now, and it does say here that there may be some deficits in intellectual functioning with Prader-Willi, but those are not required necessarily in order to receive services through the iBudget waiver under the Prader-Willi category. And again, here on the screen on this slide are the folks who need to make the diagnosis for iBudget waiver eligibility purposes, generally, again, medical doctor. Next category is spina bifida. This is, again, also pretty clearly, easily diagnosed. So you just need the diagnosis and you need it to be by one of these medical professionals listed here on the screen. The next category is Down syndrome, also very simple as far as iBudget eligibility. You have the extra chromosome 21, if yes or no, and that's your diagnosis. And they allow proof of this by medical records that show a chromosome analysis that shows the extra chromosome 21. No specific type of doctor has to perform that. You just need to have the proper chromosome analysis. The next category, the last diagnosis we're going to talk about is Phelan-McDermid syndrome. And this is another genetic disorder that's easily diagnosed and identified. So it's much simpler, and you get the diagnosis. It has to be done by a medical doctor. Okay. So the final category is the high risk category. So this is only for children ages 3 to 5. And you can receive services under this category if they believe that your child age 3 to 5 is at high risk of developing one of those diagnoses I just went through. To identify these children, they're looking at for things like developmental delay in cognition, language, or physical development, a child surviving a catastrophic or infectious traumatic illness known to be associated with developmental delay, a parent or guardian who has developmental disabilities that's going to require assistance meeting the child's needs, and a child with a physical or genetic anomaly that is associated with developmental disabilities. And so, again, I have the statutory definition, the rule definition, nothing really new there. And then, so under the high risk category, what you're looking for as far as proof for this one is the APD office is going to look for some sort of diagnosed developmental delay, or this evidence that indicates that there's a high probability the child is going to have an eventual diagnosis of a qualifying condition. So, your doctor is monitoring you for this. Your doctor suspects this and is, still monitoring you, or your doctor has it as a rule out diagnosis, but they're considering it. So, or if the child has one or more physical or genetic anomalies associated with the developmental disability. So it may be something that's not in that list of diagnoses we went through earlier, but it's associated with one of those. That can also qualify them for this high risk category. Okay. So the difference about this category from all the others, if you qualify under one of those diagnoses we discussed earlier and you're approved, you get placed on the pre-enrollment list, you're on the wait list, and one day you'll be able to get on the waiver and get services, right? If you're placed in the 3 to 5 high risk category, you are not put on the pre-enrollment list. You will have to reapply after that child turns 6 if you still are seeking services. So, or at any point, if they get that confirmed diagnosis, you can try to reapply under one of the diagnoses, even if it's before they've reached 6. Though I will warn you, the agency is hesitant to approve kids very young like that, because they can't make themselves confident that this is going to be severe and pervasive and extend indefinitely, is the reasoning that they give for that. So even though these young children are not placed on the pre-enrollment list, on the wait list, or on the waiver, they are eligible for some services through the agency, them and their families. So the Chapter 393 requires the agency shall provide services to these kids. The statute itself doesn't specify which services or how much, though. But according to an agency memo that we were sent from APD, they will provide these services under the high risk category. They'll provide individual evaluations or assessments for a diagnosis of intellectual or developmental disability. They will provide early intervention services. They will provide respite care, and they will provide support services like parent education and training, homemaker services, etc. So there are some services you can get despite the not being on the waiver or the wait list. Okay, so those are our criteria. Those are our categories. That is a lot. So let's talk about how you prove it, like practically. And this, I've got one slide on this, and I'm going to refer you back to some prior work what we have done. So what documentation you're going to use to prove your category depends on what category you're applying for. Some people have intellectual disability and autism. You can apply for both categories at once. You can apply for as many categories at one time as you think, or you believe, or you have proof that, that exist with the applicant. So if you have Prader-Willi and you also have autism, you can apply under both. You want to look to, again, the rule and make sure that your documentation, your evaluations, your records are done by the right type of medical professional that's listed in the rule for the category that you're applying under. If another note to make here is that the agency is really thorough in looking at documents. So if your documents talk about another document, you're probably going to need to provide that other document as well. The example I have is if you submit your child's IEP with their application for services, but that IEP somewhere in there, it says, per the psychological evaluation we did last year, this child needs blah, blah, blah. If they read that IEP and see, hey, there was a psychological done last year, we don't have that, they're going to come back and ask you for it. So it's best, to go ahead and try to submit all of that up front so that there aren't delays in getting your answer back from the agency after you've applied. Some general examples of the types of documents people are generally attaching to their applications are IEPs, psychological, psychiatric, or other types of evaluations relevant to your particular condition. ABA therapy records, other types of therapy records, speech therapy, occupational therapy, anything that talks about one of those 6 of 12 factors or one of the intellectual disability factors, medical records, it may be. And we did a webinar just like this one last month about hearing preparation and considering what witnesses and documents to use if you're going to go to fair hearing. And in that presentation, I spent a lot of time going through in detail, here's the factor, here's how you try to prove it. Here's the factor, what kind of document might prove that. So if you want some more detail, even though that's about fair hearing, even if you're not at the fair hearing stage yet, you're just at the application stage, that information is just as applicable at the application stage as it is at the fair hearing stage. So that is on our website, just like this will be once it's over. Okay, so next we're going to talk about, practically, like, how do I submit this application? How do I get it in? Okay. So until last month, the only way to submit your application was by mail or fax. Last month, the agency did launch a new online application, and we got to, at Disability Rights Florida, we got a little preview and got to go through the application and see how it works. So even though I haven't applied myself, I have seen how the process works, and it's, I think, pretty good, pretty clear, and it feels pretty user-friendly. I have the website here where you can apply, where you can do that online application, applynow.apd.myflorida.com. When you go there, it's gonna ask you to create an account, and you can create an account, like I could create an account for myself and then submit applications for my child and my brother, and you can submit as many applications separately under your login information as you need. So it can be used by the applicant themselves, parents, caregivers, also people like other advocates in the community who are helping people apply. So you can save your progress while you're doing that online application. You don't have to complete it all in one session, which is really helpful. And the online application has a spot where you can download or upload your documentation. So it can go right there with the online application. You don't have to send it later or separately. I will say there is no separate online application for crisis applications. The only online application is just applying for eligibility. And I'll talk a little bit, I have a separate bit of info about crisis applications later, but there's no separate button you're looking for that says crisis application. So the other option is by mail or fax. There's on APD's website, on their front page, there's a printable PDF that you can open, print, fill it out by hand, or open, fill it out on your computer, and then print. With that paper application, you have to either mail or fax it. I've had people try to drop it off and be told, no, you have to mail it. I'm not sure if every office does that or not, but the rule specifies it has to be faxed or mailed to your regional office. And in order to find out which regional office is your regional office, I have a link here to a map. So on EPD's website, I have a map of Florida with all the counties. And if you click on your county, it'll take you to the region that covers that county and have all their contact information there. So that's how you figure out where you're mailing or faxing your paper application to. Okay, application deadlines. So we're just talking about eligibility applications here first, not crisis applications. When you submit your application for eligibility for the waiver, you are supposed to get an immediate confirmation that they have received your application. Immediate is not defined in the statute. Generally, among lawyers, it's pretty quick. So I would expect you to get if you're going to have an immediate confirmation, I would expect it probably within 24 to 48 hours. My understanding with the online application is that they are sending those confirmations very quickly, like within an hour or two. So you should see some immediate confirmation of their receipt of application. Obviously, if you're mailing that application, it's going to take longer because it's going to be in the mail for a few days before they've actually received it. And then they send out all their letters. They'll respond to you in the mail saying, we've got your application. So it's going to take a few more days to get back to you. The agency's deadline for deciding if you're eligible for making a determination on your application is 60 days. They have 60 days from the day you have submitted your complete application, not from the day you start the application. But once the application is complete and submitted, they have 60 days to make their decision. There's a little special carve out in the rule that says if you're a kid who's transitioning out of the foster care system, the determination must be made as soon as practicable after receipt of an application. So hopefully that would be less than 60 days, but it still cannot exceed 60 days. And an important part of this is what is a complete application? You know, their 60 days starts ticking once that application is complete. So the statute does define what a complete application is, and it has to have three things. It has to be signed and dated by the applicant or the person with legal authority, like their guardian or their parent. It has to be responsive on all parts of the application. You have to answer all the questions. And third, it has to contain documentation of a diagnosis. So one of those diagnoses we discussed earlier, there needs to be some documentation of that attached. Now, generally, you're going to want to attach a lot more than that because you're trying to prove you're 6 of 12 for autism, or you're trying to prove, how impacted you are in your ADLs under intellectual disability. So generally, you're going to want more than just the diagnosis. But with those three things, the definition of a complete application has been met, and that's when their 60 days starts counting down. So a few more details. That 60-day deadline is not as hard and fast as we would like it to be. The agency is allowed to what they call toll the time to make the determination. So they basically hit pause on their 60 days. If if they need additional information to make a determination, or if they think they need a comprehensive assessment to definitively identify individual conditions or needs. So in the event that the agency says we need a comprehensive evaluation to make our decision on this, they are supposed to arrange for and pay for that assessment. So again, this is why when you submit your initial application, you want it to be as complete as possible as far as your supporting documentation, proving your factors or proving your ADLs are impacted or whatever, depending on your category. Because if you don't submit supporting documentation, they are allowed to take longer than 60 days to give you an answer. So try to have, it all, you want to have it all up front when you give them your application. All right, so I'm going to talk about crisis eligibility. And okay, so for crisis eligibility, you're basically saying, hey, agency, I want iBudget waiver services and I can't go on the pre-enrollment list and wait. We're in crisis and we need services now. So in the Florida Administrative Code, it's Rule 65G-1.047 that lays out the categories and the criteria for crisis. So there's 3 crisis categories that you can go through, and I'm going to go through the criteria that they look at for each of these 3 categories. I will say that there's no rule like the 6 of 12. There's not a certain number of these factors that you need to meet. You might have other factors that are not listed here, but that are relevant, that they will consider. This is not exclusive. You don't have to prove all of these or a certain number of these. These are just the general factors they're looking at for each category. So for category 1, that is individuals who are currently homeless, who are living in a homeless shelter, who are living with relatives in an unsafe environment. So the relevant criteria for category 1 that they're going to look at are whether, without immediate provision of waiver services, the health and the safety of the applicant are at risk. The applicant has no shelter available and needs emergency placement by the state. Alternative funding is not available for other placement and services to the applicant. They are temporarily staying with friends or relatives, but their residence is not expected to last more than several weeks. Their caregiver has no legal obligation to provide shelter, and the caregiver's commitment is low. Applicant safety in the current setting, that they may be at risk of physical abuse of the applicant or risk of insufficient supervision and support of the applicant. And I'm specifying here that all of these safety factors are talking about the safety of the applicant, because the second category goes more to the safety of others that may be impacted by the applicant's behavior. So there are a few more criteria under this homelessness category. So the additional criteria are that the home has insufficient room to shelter the applicant, or the applicant must share a room in an inappropriate living arrangement based on the ages, genders, and conditions of the person sharing the room. This might be an adult male applicant having to share a room with, young children, young girls, or something like that. And they'll decide, that's not really a typical living arrangement. Another factor or criteria is that the applicant's desire for placement creates a reasonable expectation they'll be cooperative with the placement. So they don't expect someone to push back on a group home placement because they're seeking group home placement, for example. Another factor is that violence or illegal activities within the applicant's current living environment, and this can be by the applicant or others, has required intervention of law enforcement authorities. Another factor, complaints of neglect, exploitation, or abuse of the applicant to protective services, or other adverse environmental conditions affecting the applicant have been investigated and confirmed. So it can be child protective services, adult protective services, law enforcement, if they've been investigating and confirming that there are adverse environmental conditions where the applicant lives, or the applicant requires services of greater intensity. So those are the criteria for category 1. And like I said, you don't have to prove all of those or a certain number of those. That's just kind of the general universe of information they're looking at when they are deciding if someone fits in the homelessness category. So this is category 2, the crisis category 2. Under category 2, they're looking at applicants who exhibit behaviors that, without provision of immediate waiver services, may create a life-threatening situation for the applicant or others, or that may result in bodily harm to the applicant or others, requiring emergency medical care from a physician. So the relevant criteria here are that without immediate waiver services, the health and safety of the applicant or others in the household is at risk. The applicant's injury to self or others is frequent or intense. The applicant or others are at risk for serious injury or permanent damage. There is documentation of medical treatment for the applicant's injury to self or others. No other supports are available to address the applicant's behaviors. Other attempted behavioral assessments and interventions have proven ineffective. Switch pages, I have some more here. The relative ages, sexes, and sizes of the aggressor and subjects of aggression place the subjects of aggression at risk of injury. The caregiver has insufficient ability to control the applicant. The ages or disabilities of the applicant or caregiver exacerbate the problems. Violence or illegal activity within the applicant's current living environment by the applicant or others has required the intervention of local or state law enforcement authorities. Complaints of neglect, exploitation, or abuse of the applicant or other adverse environmental conditions affecting the applicant have been investigated by protective services and confirmed. And the applicant requires services of greater intensity. So all of those are the world of things that they're looking at to prove that second category. And now we'll look at the third crisis category, which is more to do with the caregiver needs. So the applicant's current caregiver is in extreme duress and is no longer able to provide for the applicant's health and safety because of illness, injury, or advanced age. The applicant needs immediate waiver services to remain living with the caregiver or to relocate to an alternative living arrangement. So the relevant criteria here are that without immediate waiver services, the applicant's health and safety are at imminent risk. The other potential caregivers, such as another parent, step-parent, etc., are unavailable or unwilling to provide care. The caregiver's physical or mental condition prevents the provision of adequate care. The caregiver is deceased, about to expire, or permanently disabled. Caregiver's age impairs their ability to provide sufficient care to applicant. Caregiver cannot provide sufficient care because of the age or size of the applicant or the physical, functional, or behavioral demands of the applicant. Services provided by the caregiver are limited in amount, duration, or frequency, rendering this applicant semi-dependent or totally dependent. The caregiver's economic situation is unstable and unlikely to improve as a result of the caregiving demands of the applicant. The caregiver's obligations to the needs of other dependents prevent them providing the applicant with adequate care, or the caregiver's obligation of care to applicant places another dependent at risk of insufficient care. Violence or illegal activities within the applicant's current living environment by the applicant or others has required intervention by law enforcement. Complaints of neglect, exploitation, or abuse of the applicant or other adverse environmental conditions affecting the applicant have been investigated by protective services and confirmed, and that the individual requires services of greater intensity. So those are your three categories and the criteria that they're looking at to prove each of the three categories. And these categories, the categories for crisis are not mutually exclusive. You might meet more than one. And so when you are wanting to apply for services under crisis, I would talk about as many of these things as I could. And I'm going to talk in just a second. I'll talk now about how to actually submit that application. So again, like I said, there's on the website, whether you're talking about the online application or the printable PDF, there's no separate crisis application. So generally, crisis applications are done by writing a letter that details all the facts that are going on, and then attaching supporting documentation and submitting it to the agency. So like I said, those factors, you might meet more than one category at a time. You might meet some or all of those factors, and I wouldn't rely on just one or two. I would talk about every single factor that I thought we were meeting in my situation. If that letter is 10 pages long, so be it. So you're going to want to write your letter and attach it as much documentation as you can, whether that's police reports from DCF, from their investigations. It might be work schedules of the caregiver. It might be medical records of the caregiver. It might be school records. It might be records about the other children in the home, injuries to them, those sorts of things. Go back to your factors to look at what kind of documentation you'd want to attach to prove them. And so then how you submit can depend. If you're currently applying for eligibility and you also want to apply for crisis at the same time, you can do that. So you can do that either in the mail version or the online version. You put your application, if you're currently applying online, if that application isn't submitted yet, it's still open and you can attach things to it, you can do it right there. You can, when they say, okay, so, attach your supporting documentation for your eligibility, you can also attach your crisis letter and any documentation you have for your crisis letter. So you can do that right there in your online application, do both at once. And then if you don't have a currently pending eligibility online application, then you are going to want to submit it by mail or fax, just like you do with the original application. And you can find your region, you submit it by mail or fax to your region, and you can use that same link I provided earlier in the slides to find which region is the right one for you. Yeah, whatever your preference. And if you do have an online application, you can still submit your crisis application and materials by mail if that's your preference. You don't have to stick with what you used before. You can go by your own preference and your own needs. So the last little bit here is our deadlines for crisis. And again, you're going to get an immediate confirmation that they've received your crisis application. That immediate, what immediate means is again going to depend on whether we're doing this online or by mail. Once they have your application for crisis, they have to make a determination within 15 days of receiving that. And then the last little note I wanted to make is that crisis enrollment is depending on funding availability. So even if you meet every single factor in every single category, if there is no funding, then they still may not approve you for crisis. So as frustrating as that may be, I just wanted to explain that as well. So I know this was a lot. It's a ton of criteria, a ton of factors. All of this is going to go on the website. And most of the language in this presentation is taken directly from the statute, directly from the rule, but always feel free. These things are available online. You can search the Florida statutes. You can search the Florida Administrative Code. That's why I put the rule numbers in there to help you be able to find them. these things aren't just for lawyers, anyone can access them. And again, if you're needing more clarification or assistance, always feel free to contact us. And here's our contact information on the screen. You can contact us by phone, we have TDD, you can contact us online, our web form. If you need accommodations to speak with our first team, we will accommodate you.
All right, thank you, Caitlin. Appreciate the time you took. I know this was a lot of material. So again, I want to reiterate what Caitlin said, that we have a lot of questions to get to. We probably won't get to all of them today. So you can please feel free to call our office or go online and ask the questions if we don't get to it. So before we take questions, I do want to bring to your attention the QR code on the screen. It will take you to a short survey asking for your opinion on the content presented today. We would greatly appreciate it if you could take a few minutes to give us feedback so that we can continue to improve the programs that we offer. There's also a link to the survey in the chat so that you can use that if you prefer not to use a QR code. You can scan the QR code or click the link now and wait until after the question answer session to complete it. So we do have a couple of minutes. I'm going to ask a couple of questions of Caitlin. And again, if your question did not get answered, please feel free to call our office or go onto our website and click on help, and you will find that you can contact our intake staff there. So our first question is, sorry about that, I just lost it. Okay, how many years should I go back on a submitted, how many years back should you submit documentation for? If the application is being submitted, for example, at age 12 and the diagnosis was age 2, do you go back through 10 years or less?
So, I wouldn't say you need to include every bit of documentation for that whole 10 years. You need the diagnosis. That's one of the 3 main things required for a complete application. So you may need that 2-year-old diagnosis, but then when you're proving severity and pervasiveness, when you're looking at those 6 to 12, you're going to want to look at more current day records, probably back 2 or 3 years, though that's always with the caveat that the agency may ask you for more.
Thank you. And is someone able to apply for an adult child who is over the age of 21?
Yes, so you can submit an application on someone else's behalf but it has to be signed by the applicant or someone with the legal authority to sign. So if you're a parent of an adult child, that child is, say 25, unless you're their legal guardian, they do need to sign the application, but you can create an account and submit it for them. If you're asking whether you can submit an application if they weren't diagnosed prior to age 22, yes, you can also do that. You're not required to have a diagnosis prior to, like during your developmental period during childhood. What you're required to have is proof that the condition manifested. So especially with some older folks, we used to call autism different things. We used to call it pervasive developmental disorder or other things. So if an applicant is 60 years old, they might not have an autism diagnosis until, they were 50. And all before that, all their records say pervasive developmental disorder. Do not be off-put. You can still apply. I have spoken with the agency directly about this recently. They understand the difference between something that manifested prior to adulthood versus diagnosed prior to adulthood.
Thank you. What if APD never replies after you submit an application?
That can be difficult. When that happens to us, typically we'll start off by calling the ROM, who is the head of the region that you applied in. You can find the ROM's information with that map that I linked. When they pull up the region's information, it also lists the name and email address of the ROM. So first I will contact that person. And if I don't get anywhere with them, then I will start contacting the state office.
And you may have answered this. I could not remember, Caitlin, so I apologize if you did. If an application was submitted via mail, can we still create an online portal to follow up on the status of the application?
You know, I haven't been asked that and I haven't seen that. The new online application is pretty new. So I'm not sure I know the answer to that 100%. My suspicion would be that no, that you can't, because I believe that they're only providing the updates and documentation in the online portal attached to the online applications. So I think the answer is no, but I'm not 100% sure.
All right, thank you. If you're on Social Security disability, can you apply?
Oh, yeah, absolutely.
All right. Providing crisis information, aging parents' health concerns isn't going to get a person removed, correct?
So we hear this a lot. This is something that a lot of people have fear with, and with children. The other way is true too. You know, if you're arguing, you know, my adult child with autism is injuring my younger children, people are afraid that their younger children are going to be taken by child protective services. And what I have to say to that is I worked in the foster care system for many years. And it is always better to identify and address the problem than to try to keep it a secret. So the fact that your adult child might be injuring their elderly caregiver or injuring their minor siblings, if that's happening and you are actively seeking services, you are trying to get help, you are, calling the therapist, you're doing all of that, like that's the best you can do. And I would not you should not have to worry that you're going to lose your kids or the caregiver is going to lose the ability to provide care for the applicant. This should be seen as you taking proactive steps to manage the situation. So I understand that fear. I absolutely do, but it's always better to be honest and seek the services, apply for the services to show that you're doing everything within your power to mitigate any danger or harm to others in the household.
Thank you. All right, if APD asks for more information and I dropped the ball and did not respond, how can I pick that back up and send them information for my daughter?
So if they ask for more info and you didn't respond, it depends if they it may have gone so long that they said, okay, well, we'll just make a decision with what we have, denied. At that point, you may have to reapply. If they haven't done that yet, if they're just still kind of waiting and it's been a while, I just reach back out, respond back to that email and say, so sorry, I was busy holidays. Here it is. It should still be okay as long as they haven't made that final determination yet.
All right, thank you. So we are over our time right now. I'm going to ask one more question and then we're going to conclude the webinar. Does a child being on Florida Kid Care health insurance make them ineligible or vice versa?
Nope, absolutely not. You can be on, many people on the waiver are also on Medicaid, and their waiver services are funded through the waiver, their Medicaid services are funded through Medicaid, and the same applies with Kid Care. They do not preclude each other.
All right, thank you so much. This concludes our webinar for today. The webinar and the PowerPoint slides will be available on our website in about a week. We want to thank everyone for joining us and have a wonderful day, everyone.